for rebuttal.
Your Honor, I'd like to reserve 5 minutes, please.
Very good, sir. Whenever you're ready, I believe the panel is ready, sir.
Well, good afternoon, Your Honors. I'm Steve Brannick of Brannick, Humphreys and Berman, representing Dan and Melinda Davis, the appellants here. When the developer sold the Davises their lot in the subdivision, it gave the Davises a deed that sold the property, quote, free of all encumbrances, close quote, except for covenants and restrictions of record. It is undisputed that at the time of the closing, there were no covenants and restrictions of record. In fact, the developer didn't record those covenants and restrictions until 6 weeks later. And now the developer wants to enforce those restrictions against the Davises. We think the case is very simple. The restrictions that the developer recorded 6 weeks later are irrelevant. The Davises can't be bound by restrictions that weren't of record at the time of the closing, that didn't exist at the closing, and the developer can't later restrict property that was already sold. Now, the HOA's response is many variations on the same theme, which is that the Davises always knew that the developer intended to record restrictions. But Florida law says that that intention is irrelevant. Under the long settled merger doctrine, any intentions of the parties, indeed any prior agreements of the parties, are merged into and superseded by the deed. Thus, the language of the deed controls. This case is very similar to the voluntary title case, which is the granddaddy case on the topic. In that case, the purchaser bought a lot in the subdivision knowing that the developer intended to impose restrictions. In fact, some of the other deeds of other lots, in fact, had that restriction, and at least one of the contracts that was at issue noted that the restrictions would be in place. All of that was irrelevant because the purchaser's deed was silent. It contained nothing about any restriction. And the Florida Supreme Court said that the language of the deed controls. Any notice of the restriction, any knowledge of the restriction, any agreement for a restriction before the deed was simply irrelevant. And this has been Florida law ever since, and for good reason. Everything about real estate law is designed to promote certainty in title. That's why real estate transactions have to be in writing. That's why we have a recording system that puts buyers on notice. That's
well, Mr. Brannick, if that were so, if certainty were the issue, then your client was not certain at the closing that the CCRs were recorded and he didn't care. It seems to me that you're asking us to ignore his conduct and the agreements that he made prior to purchasing this. How many other lots are there in the subdivision?
It's a small subdivision. I don't remember exactly how many, 8, 9, 10, something like that.
Seems like he got the best one, I think, is on the corner or something like that.
He was the first one in, yeah. So
yeah, it looks like the best one. So I commend you because you know, you're fighting a tough case because your client agreed to these CCRs. He believed that they were recorded. He thought they were reasonable, and he testified he thought that his property was encumbered by it. And the facts definitely show that he acted in conformity therewith for 10 years.
But this is where I disagree.
Well, yeah, he did because he joined the HOA and participated in the HOA, and he believed his property was encumbered. And he signs a sales contract that says property is subject to restrictive covenants governing use and occupancy. CCRs have been and will be recorded. And then his title agent at the closing goes, "Hey, Dan, they're not recorded. You still want to buy this property?" He goes, "Yep." So you didn't file a breach of contract, correct, below?
No, this was a quiet title action.
This is an action in equity, is it not? This is an
Pardon me?
equitable action. Equitable action.
Yes, you're
Okay. He who seeks equity must do equity.
Right.
So we can't ignore your client's knowledge. He seeks to be relieved of the inconveniences and detriments of the CCRs to which he agreed, to which he never challenged when they were recorded shortly after the closing. So in the merger docket, according to the Frazier case, is if the buyer knows about violations of a building code before closing and still purchases without knowledge, the merger doctrine doesn't apply. Your client knows. This isn't a case where he's not informed about it, and he doesn't ask about it, and nobody ever tells him that these things are going to happen. Why are you asking us to ignore those and just focus on a clause in a deed?
There's a lot to unpack in Your Honor's question there, so let me try to address them in turn. First, Your Honor stated a couple of times that the Davises agreed to the homeowners restrictions.
Yes, he said so in his deposition. He said that he agreed they were reasonable.
He knew that the developer intended to impose those restrictions, but Florida law tells us
he agreed that they were reasonable. If you want me to point out the page, I will.
Right, but
go ahead.
If I may answer, Your Honor, the question though is where is the agreement? And Florida law tells us where we look to the agreement. We don't look to conversations that take place at closing. We don't look to conversations that take place before closing. We don't look at agreements that were signed before closing. We look to the deed. The deed is where the agreement is. And what does the agreement say? That deed says that they are taking free and clear of encumbrances, except for encumbrances of record, clear as a bell. That's where the agreement lies. Now, Your Honor is suggesting that there perhaps was some agreement that was formed after the closing by their actions. That's sort of a ratification kind of argument, but the problem with that argument is that ratification is an issue of fact that has to go to the jury. It can't be decided on summary judgment like here. Ratification requires a knowledge of the true facts. At the time that the Davises participated in the homeowners association, they weren't aware that those restrictions had not been recorded. So they weren't in possession of the true.
During those 10 years, when did he ever relate to anybody that's in the record that he didn't believe they were recorded? When? Yeah.
Well, in 2000.
Give me that evidence in the record that he never knew this.
There were, I think, two key pieces of evidence. One is in 2013, the developer comes around, the homeowners association comes around and asks the Davises to ratify the second amended restrictions. And the Davises said, no, we're not going to ratify that. We want to preserve our position. That's number one. Number two,
right. Preserve the restrictions that do apply. I don't want the new ones that Sunrise wants. I want to preserve the ones I already have. That doesn't help. Give me the second one.
Well, my recollection is that the language says preserve our position, not preserve the original restrictions.
No, it doesn't say preserve your position in a lawsuit, because he didn't have a lawsuit then.
But
it preserves my rights under the restrictions I executed, provided the new restrictions would apply additional restrictions to my lot, which are not customary allowed to be mended.
But
so my language of that is he is using the restrictions that you're saying he didn't agree to as a sword.
But my point is, though, Your Honor, that they were presented with additional restrictions in 2013 and they refused to sign number one. And then they made their position absolutely clear in 2018 when they wrote to both their title insurer and the homeowners association as we've discovered that these are not of record and we don't believe that they're bound by them. And they're fully supported in Florida law by the merger doctrine and the volunteer title case. In the volunteer
case, there's a really big distinction in the volunteer case. The court really focuses on the fact there were no restrictions indicated by the plat or otherwise by anything in the record. You have, this record is replete with your client, first of all, asking what are the restrictions, then getting a copy of them, and then seeing that the same copy was actually recorded weeks after the transaction. And his title agent said, Dan, they're not recorded. Your client, I don't care. I really want this lot.
Yeah. I respectfully disagree with Your Honor's interpretation of volunteer title, because in that case, there was no doubt that the purchasers were on notice of the potential restriction. The Supreme Court said that doesn't matter because it's not in the deed. Then on rehearing, the plaintiff said, here, we're going to file this amended complaint. We're going to include all these additional arguments about why there was notice. And the Supreme Court said it doesn't matter. All that matters is the language of the deed. So we think think the merger doctrine controls, but
Mr.
I'd like to.
Can I jump in? Maybe it follows what Judge Sleet was asking. My understanding was the Davises signed an HOA disclosure. And in that HOA, my understanding is that, first of all, it does confirm that they'll be obligated to the HOA, describes that payment of assessments, and then it identified the developer's right to amend the restriction without the Davises' approval. And then it encourages the Davis to refer to the restriction. I'm looking at it right now to understand their rights before closing, and explains that the restrictions are either matters of public record or are not recorded and can be obtained from the developer, and further that they have been or will be recorded. So help me out with that, Mr. Brannick. If that was before closing, it kind of follows what Judge Sleet was asking you. If they've been put on notice and they're aware of that, how do we get around that?
Well, first, there's no one's disputing notice here, so we can put that aside. No one's disputing notice. What we are saying is that notice prior to the closing, notice prior to the transfer of the deed is completely irrelevant. And under the merger doctrine, all we look to, and the Florida Supreme Court tells us in this court, in the Stevens case, tells us that all we look to is the deed. Otherwise, if we're talking about, if what we're talking about is notice, then that turns every property transaction into a swearing match. That's why careful real estate scriveners are careful in the language of the deed, and they're also careful in how they handle their documents. All the developer had to do here was either one, write the deed differently so that it made it clear it was subject to later recorded documents, or two, record the darn documents before the closing. The developer is the one that screwed up here and is looking for the get out of jail free card. But in addition to the merger doctrine, they have another serious problem, which is that they have conceded in their brief, quite correctly, that these restrictions have to be effective prior to the closing or they're not enforceable. And it's 720.301 that tells us that. It says for a small community like this one, less than 15, the deed restrictions have to be effective prior to the closing, or they're not binding on the person that purchased. And so the question is, how do you make those restrictions effective? There's no doubt that there was a draft of these restrictions prior to the closing, but it was an unsigned draft. So when were those restrictions first signed? They were signed in May, 5 weeks after the transaction. Here's the language of those deed restrictions. It says that the developer declares that the property will be subject to the restrictions in the declaration. And when is that declaration made? It's made on May 9th, 2008. How in the world, when the developer is declaring as of that date that the restrictions are effective, how can they say that those restrictions were effective prior to the close? Then they say, well, that's really all irrelevant. You can record later, but that's not what the HOA statutes say. And if you look at the whole framework of the HOA statutes in Chapter 720, they make clear that in order for the deed restrictions to be effective, they have to be recorded prior to the transaction. Look at the language in 723.03.1, which I cited before. The covenants can only be enforced if they were established prior to the sale. 723.03.1 also states that the initial governing documents must be recorded. 720.301.4 defines a declaration of covenants to be a recorded written instrument. 723.01.8E defines the governing documents to be a recorded declaration of covenants. The homeowners association statutes are replete with requirements to record these documents to make them effective. And why? Is because we don't want to have a case like we have here where there's a swearing match about whether restrictions are imposed or not. That's why in real estate law, we dot the T's and cross the I's. Judge Sleet, you were on the Lydie case along with Judge Kelly that we cited the supplemental authority. I think it's a perfect example of that. It's another case around 720 and its requirements. In that case, MARTA, of course, as we all know, extinguishes covenants of record after 30 years. And that's a problem for homeowners associations because sometimes these subdivisions last for a long time. So the statute says you can renew your covenants. All you have to do is file them before the 30 years expires. But what did this HOA do?
Mr. Brannick, I don't want to interrupt you, but you're about to get into your rebuttal time, sir. Just wanted you to be aware.
Thanks for the heads up. So I'll conclude on my day. So the what did the homeowners association do? They filed a notice of renewal, but they filed it 2 years too late. So they did it 32 years after instead of 30. And what did this court say? It said, sorry, you have to dot your I's, you have to cross your T's. It doesn't matter that these restrictions are going to disappear. The statute tells us how you have to do it. You didn't do it that way. Therefore, homeowners association, you lose. That's exactly our point here. And it's not a gotcha sort of thing. It is designed to ensure that when I buy a piece of property, when you buy a piece of property, when anyone buys a piece of property, they know exactly what they're getting because it's there in black and white in the recording statutes. So I'll leave my remaining time for rebuttal.
Actually, you have about 4 minutes for rebuttal, Mr. Brannick.
Thank you, Your Honor.
Okay. Mr. Lyman, whenever you're ready, sir, the court is prepared.
Good afternoon, Your Honors. May it please the court, Chance Lyman on behalf of the appellees. Judge Sleet, you said it, this is a case of equity. All roads lead to equity in this case. And I want to just point out that the equity really begins at the beginning of the parties' interactions, not the parties rather, but the developer and the Davis's interactions. Mr. Davis asked the developer directly what restrictions apply to the lot. That's a present tense, what do they apply? He received the declarations in response. These are the restrictions. So he never has debated that those are any different than the ones that were recorded and signed later. That's established. So this is the beginning and the end of the equity here. Your Honors have just discussed all of the other documents that he signed that confirm this position. Obviously, Judge Sleet, you highlighted the 2013 email. You read it. I agree with you. It says that Mr. Davis is acting and knows that the restrictions bind his lot. I would be remiss if I didn't address the deed language. I heard it again at the beginning of the oral argument here at the appellant's presentation. He said the deed says covenants and restrictions of record. Your Honors can obviously read the deed for yourselves. It does not say that. I don't know if I want to really belabor that point in front of you other than to say that it says covenants, restrictions, easements of record, and taxes for the current year. I really want to highlight in the reply brief on page 2, this is something that I think just proves as a matter of law that appellant's interpretation is patently unreasonable. On page 2 of their reply brief, they are applying the last antecedent canon and the series qualifier canon together to the same language. And those are mutually exclusive canons. I think that proves that their interpretation really doesn't make any sense under either canon. But at the end of the day, we've cited the Wong case. It clearly says that when you're dealing with a series, you can't apply a modifier that occurs in the middle of the series. I think this is really just a simple question of grammar. The syntax of the sentence is a series. It's critical where the conjunction is placed for purposes of any of those canons. As we pointed out in our answer brief, there are a lot of times in the initial brief where the appellants modify the deed language, sometimes in quotes, sometimes with brackets. And they're doing that because they're putting the conjunction in a different part of the sentence, because frankly, that reveals that they need the conjunction to be where they're putting it. So I think that really resolves the issue. The other thing I would like to talk about is, there's no concession in our answer brief that these declarations were not somehow effective. Really, the point is whether they are established or not, because that's the language in the statute. And I appreciate that the appellants have just filed supplemental authority a few days before this oral argument, where apparently they discovered 6 or 7 Florida statutes in a 2019 case from this court. Obviously, the MARTA case, the statute has nothing to do with the issue that's here. The only issue is whether established might mean something beyond recording or signed. It really, the 720.303 doesn't say, and established isn't effective. I mean, that's not the same word. And so frankly, if statutes are using different words in different places, that must mean they have different meanings. So, you know, this 723.031 doesn't say when recording has to happen, and it says nothing about signatures. So one other point is the volunteer case. You know, Your Honors, your Judge Sleet, you distinguished it. Background is material. That's what's critical about volunteer. The background is material, and the Supreme Court didn't change anything about that statement when they denied rehearing. They still kept background as critical. So we've got critically different background here. One other really big important point is in volunteer, the deed didn't say anything about restrictions. And I think I heard appellant concede that, and I agree with him. The deed didn't say anything about restrictions. Obviously, our deed does. So there's another materially different background fact. You know,
Well,
yeah.
I mean, if this were a purely contractual cause of action, we could look at this and maybe include the parole evidence rule, because I think Mr. Brannick has a tough case. He's trying to make the best of it, but he's trying to get us to exclude any other evidence related to the negotiation of this transaction. I mean, it's a case of equity. Aren't we not allowed to consider all the circumstances?
I think that's absolutely true, Your Honor. And I'll also add that, you know, this was a summary judgment case, but there was no counter evidence that supports anything other than appellee's position about what those conversations were, what that parole evidence would have been, you know, that there's simply no counter evidence.
Okay, so let's see if this fact is not disputed, because I know in Ms. Carter's affidavit, she alleges that the title agent during the closing did advise Mr. Daniels that they were not recorded, and she audibly heard him, or otherwise the title agent represented him saying, "We're going to go forward," and then he knew they weren't recorded. Correct?
Correct.
That's an undisputed fact, is it not?
That's correct.
Okay, so it's not something that's in conflict that a jury needs to resolve.
Absolutely correct. And certainly at the summary judgment phase, nothing, I mean, that's a critical phase. If they had counter evidence, that's when they needed to present it, and they did not. So that's absolutely an uncontested fact, undisputed. And, you know, I just want to, there were 12 lots in this subdivision. If that's important to the panel, I just wanted to add that fact since you asked about it earlier. Really, Your Honors, if there are no other questions, well, I do just want to talk briefly about the Romack case, because really, even if I'm wrong about what the deed says, and I certainly don't think I am, Romack is dealing with a deed that says something is recorded when it's not. Clearly, if the merger doctrine worked the way that appellant is arguing, then Romack would have been decided the exact opposite way, and it wasn't. Instead, you've got something that's a deed that says something is recorded. It's really not. It turns out this court said, no, actually, the notice is enough to now apply these restrictions to you. And so I really just think that ends the issue if there is anything left after the deed is, you know, construed according to its plain language. Again, if there are no other questions, I'll rest.
I believe there's any questions. Thank you, Mr. Lyman. Mr. Brannick, I believe you had 4 minutes, sir.
Let me just start briefly with what happened at the closing. Clearly, there's a dispute about what happened at the closing. They submitted an affidavit that said they had this conversation in which the Davises agreed that these restrictions could be recorded later. Both of the Davises testified that they had absolutely no recollection of that conversation. And what I think is important and what's completely missing here is there was a title agent there. Where's the testimony from the title agent? There isn't any testimony from the title agent. Where's any evidence of any contemporaneous documentation of that so-called agreement? Well, there isn't any.
But your associating counsel below didn't seek to exclude that by way of hearsay within an affidavit. So it stands. It stands, and that's not an issue on appeal. So it stands. It's admissible evidence. The fact that your client cannot. Don't interrupt me, please.
So sorry.
Don't. The fact that your client can't recall is immaterial. It doesn't raise an issue of fact. In this situation, you know what this is like? This is like a subdivision with a runway. And they tell the people, and your client gets there first, that only single engine Cessnas can land on the landing strip. And he goes, well, I want this corner lot right here. That's what I want. Well, we don't have the restrictions filed yet. Don't matter. I like them. They're reasonable. I just want this lot. So he rushes through there despite what his title agent tells him. 10 years later, doesn't do anything. John Travolta comes along. wants to buy the property. He goes, John, there's no restrictions. You can land your 737 here. Go ahead. That's what you're asking us to do. Is that equitable?
What we're
Remove
asking,
all the restrictions to your client's property that he agreed to.
what we're asking this court to do is to follow Florida law on how you determine what a person's interest in title is. And we're not talking about a contract here. We are talking about a deed. And Florida law is absolutely clear that you determine the quality of a person's title, including what easements and restrictions and covenants you're subject to, by the language of the deed. Any other agreement is completely irrelevant. That's the argument here. And that's what the volunteer security, the volunteer title case says from the Florida Supreme Court. This court has followed that rule many times. Your honors have held folks' feet to the fire many times in other real estate situations. It's because real estate, we need certainty. And we need certainty, and the way we get certainty is by making sure that the deed is drafted properly, and by ensuring that matters are made of record, that there is no question about whether something has been established or not. So, for all of those reasons, Your Honor, the fact that, number one, the merger doctrine says that we look only to the language of the deed, and number two, the fact that these restrictions were not established until at least 5 weeks after this transaction, we think that the decision below needs to be reversed.
Thank you, Mr. Rank. Thank you, Mr. Lyman. It really is incredible to hear well-prepared attorneys presenting their case very passionately. So thank you both. You both did a great job. Thank you. All right, and then the next case on our docket is Johns Hopkins All Children's Hospital versus Jack Kowalski.